Hi everyone, Chris Camburn, 1406 Financial and Annuity Nest here with a video on inherited IRAs. I'll post this to both channels as the subject matter applies to IRAs regardless of what investment you have inside it. If you inherit an IRA, these new rules apply. And they're a little bit different from the old rules. And I'll show you who was most affected here in a little bit. But these rules stem from the Secure Act passed in 2019. So all of these rules have been in effect for a few years now. But I saw some interesting cases this year with inherited IRAs where one person was within 10 years of the deceased and another person was younger than 10 years of the deceased. And so different rules applied, and I realized how there are maybe some strategies or some actions to take depending upon your relationship to the deceased and your age disparity or difference in ages. So let's get into it. It was back in 2019, I'll put this up on the screen, that Congress passed the Secure Act, setting every community up for Retirement Enhancement Act of 2019. So this is the website for the Congress, and then here's the bill in PDF form. And let me tell you, this stuff is tough to read. It took like 4 or 5 hours going through this stuff to make sure I got information right for this video. And although the rules are not that difficult necessarily, it's just trying to find an edge, trying to get an edge here, and they're making it more difficult. We had done a lot of work previously with families for stretching IRAs for spouses and for children, and this has really affected that a lot. So let's get into what the rules are. Maybe we can touch on a little bit of what they were and now what they are, and now some ways to gain an edge and some ways that it's just not going to be possible, but how to work with it the best you can. So let me get my cheat sheet up on the screen for you here. What we're seeing here is it's a grid I created with regards to, all these things. It's a grid I created to help, just to give you a visual. I'll let you see here like a chart, a guideline for what your decisions might be. So first you have to consider what your relationship to the deceased was. And so here I've put things such as if you're a spouse who's less than 10 years younger. Well, first of all, if you're a spouse, that's the most advantageous. That's the most advantageous beneficiary to be because you have the most flexibility. Where am I? There I am for you. So if you're a spouse, you have the most flexibility. And if you're a spouse who's less than 10 years younger than deceased, you can treat the IRA as your own, or you can treat it as a beneficiary IRA. And here I have some things of note at the bottom we'll get into in a moment. But if you treat the IRA as your own, you become the owner of your IRA. It has your name on it. And then it becomes an IRA I'll just say that as you become accustomed to. You manage it, you invest in it, and once you're age 72, if you're already over age 72, at age 72, you have to start taking those required distributions. Now, keep in mind, you can always take more than required distributions, but there is a minimum required every year. And there's these tables that we get the minimum required distribution from. You take the account balance as of December 31st of the prior year. You divide it by this factor that the IRS provides to us or to you, and that's how you know how much to distribute from your account for the year. And so what you use, it's called Table 3. It's a uniform life table. And where I get that information from, if you want to go to the source, like I love going deeper than just taking things face value. Hey, where'd this person get the information? It's the IRS publication 590B, Distributions from Individual Retirement Accounts. And this is the rule book. Right? So this is where all firms like mine or the firm you're working with, this is where we go for information, and this is where we go for the rules. And here in this publication, towards the end, I'll go there. Sure, why not? You get these tables 1, 2, 3 that show you how much to take out. So for instance, here's table 1. And, when you see these tables, what you do, well, let's just take someone who's 66. I decided to use age 66 as some examples for what I'm doing today. So we're in the year 2022. If you had to take distributions from a deceased spouse, if you had to take distributions based upon life expectancies from an IRA, you take their December 31st, 2021 balance and you divide it by 22. So let's take just a $100,000 IRA, for instance, divide it by 22. You'd have to take out $4,545.45. As a matter of practice, I always round up to the next dollar just to make it clean. So, but the minimum is $4,545.45 that you'd have to distribute by the end of the year. You can always take more, but there's a penalty if you don't take at least that minimum. It's called a minimum required distribution. So that's table 1, and other tables that I reference in the presentation today. We have a table 2. That's if you're more than 10 years younger, and table 3 is uniform life. So this is if you have an IRA, whether it's your own from the beginning, or if you've inherited an IRA that you make your own. Table 3 is the table you use, and you can see that table 3 starts at age 72, which is the age for minimum required distributions. Now the other table starts early because if you're not eligible to make the IRA your own, you have to use the other table. It gets monies out a little bit more quickly than this table. But here's the thing, this starts at age 72. So again, let's just do some calculations. If this was your IRA and you're age 72, you'd have to take out $100,000 divided by 27.4. Let's assume a $100,000 beginning account balance. You'd have to take out $3,649.63 by the end of the year. That's the minimum. You can always take more. But so when we get these required minimum distribution calculations for you, this is how we do it. We take your account balance at the end of the previous year, divide by the factor, and it comes up with the number that we have to distribute. Luckily, the computer systems are really good at this point. They do all the calculations for us. You know a few days after the beginning of the year what your distribution is. But that's where we get, if you're like, hey, where do these people get these numbers from? That's where we get the numbers from. So let's get back to my cheat sheet slide. And I think where I left off was, if you're a spouse who's less than 10 years younger, that you can treat it as your own. You can treat it as a beneficiary IRA. And then you apply it to the table. And now here's the thing. If you're a spouse, you don't have to begin distributions. Now, the reason this is getting into why you want to treat it as your own or treat it as a beneficiary IRA. As a spouse, if you inherit your spouse's IRA, you don't have to take distributions until your spouse would have been age 72, right? So if you're each 66 and your spouse passes, you don't have to take, if you treat it as your own, well, in either case, you don't have to take distributions for 6 years. You don't have to take distributions until your spouse would have been age 72. And so that's but now if your spouse is, so let's look at this. So that's age 60, if you're both 66. Let's say that you're age 60 and let's say your spouse, you're the beneficiary. You're age 60, your spouse is 66. So they'll get to age 72 before you. Well, in that case, if your spouse was older, you're going to want to treat the IRA as your own, so that delays when you have to start taking minimum required distributions. Now keep in mind, it just delays when you take minimum distributions. You can take distributions at any time, at any amount. Just when you get to age 72, that's when the minimum required distributions kick in. All right, so if your spouse is older, more than likely it makes sense to put this IRA into your IRA, make it your own, so you can delay when the mandatory distributions begin, but you still have the flexibility of distributions at any time. The reason you may want to treat this as a beneficiary IRA, let's go in the opposite direction. You're 66 and your spouse is 60, and your spouse passes away. So your spouse is 60, you're 66. Well, if you treat this as your own IRA, you're going to take mandatory distributions begin when you're age 72 because it's your IRA. So these monies are in your IRA. You have to start taking money out by age 72. However, if you keep it as a beneficiary IRA, now you don't have to start taking distributions out until your spouse would have been age 72. So that's in 12 years. So what you can do is just let this ride, and after 12 years, you'd have to begin distributions. Now, the trick here is that in year 12, you're going to want to convert the beneficiary IRA into your own, and that's because those factors, the distribution schedule is a lot faster in a beneficiary IRA than if the IRA is your own. So you know that you have to distribute monies at age 72, and it starts around 3 or 3.5% a year, and it goes up a little bit every year. Well, as a beneficiary IRA, those distribution schedules are designed to exhaust your money within about a 15 or 20-year period versus over your entire life. So the beneficiary IRA distribution schedule is a lot quicker. It's a lot more it's more accelerated, I guess, if you can say that. It's a faster schedule than if you have the IRA as your own. So that's a little bit of a trick. Just if you have different ages, if you're different ages, understand you don't have to start taking distributions until age 72. If it's your IRA or the deceased spouse is age 72, and just got to look at it to make sure that the schedule lines up or the distributions line up with what's most advantageous for you. Now, if you're a spouse that's more than 10 years younger, again, you can treat it as your own or as a beneficiary IRA. But if it's a beneficiary IRA, there's this table too. There's a table out there for when a spouse is more than 10 years younger, or a beneficiary spouse is more than 10 years younger. It's a little bit of a slower schedule than that other table 1. So it's a little bit of a slower withdrawal, but still not as beneficial as if it was your own. So if you inherit an IRA, being a spouse is the most beneficial position to be in, but not everyone who inherits an IRA from their spouse. I mean, we have, in life you have people who have receive IRAs. Let's just get over here real quick. Now listen, we have people who inherit IRAs who are brothers and sisters and then children. So that's the most common I see. The most common beneficiary designation is a spouse, and then the second most common is a child. Now, when I say child, it could be any age. I mean, it could be a minor child, or it could be an adult child. And then the third most common designation I see is when somebody's a brother or a sister. So something to be aware of here is now the important thing is it's your age difference relative to deceased to figure out how you make distributions if you're not a spouse. So let's go back to the chart here. Which pen do I like? Can I remember which marker? So there's something to be aware of. It's the distribution schedule is based upon your life expectancy. If you're not a spouse, there's two other ways to distribute monies based upon life expectancy or simply over a 10-year period. Now, over a 10-year period is the quickest pace for distributing funds. Well, that's interesting. As I was recording this and thinking about it, the 10-year distribution rule. Let me make sure I go through this first. If you're not a spouse and you inherit an IRA, you may be subject to one of two distribution schedules. And it depends if you are an eligible designated beneficiary or not. So who's an eligible designated beneficiary? An owner's surviving spouse, well, we already covered that. A minor child, that means under age 18 or 21, depending upon state rules. Chronically ill individual, disabled individual, or this is the kind of an interesting catch-all. Any other individual who is not more than 10 years younger than the IRA owner. So any other individual who is not more than 10 years younger than the IRA owner. So if you are, where I've seen this now in practice a few times, is brothers and sisters. I've had siblings who are not more than 10 years younger inherit an IRA, and I've had siblings who are more than 10 years younger inherit their deceased siblings' IRA. So this is interesting. So if you are not more than 10 years younger, you're 65 and your deceased sibling was anywhere from 74 to 57. Well, not 10 years younger. So if you're 65, as long as your deceased sibling was 74 or younger, you're not more than 10 years younger. All right. So I think you'll know if you're within 10 years of your brother or sister. And so if you're not more than 10 years younger, you can use the life expectancy tables. If you're more than 10 years younger than your deceased sibling in this case, it's a 10-year distribution schedule. Well, it means you have to distribute monies within 10 years of your siblings passing. So we're in 2022 right now. That would mean you have to distribute all the monies by December 31st, 2032. That's if you inherit an IRA this year. If you inherit an IRA from someone in 2022, you have to distribute all the monies by the end of 2032. Now, when distributions must begin, with a 10-year rule. I'm getting ahead of myself here. So if you are not more than 10 years younger, it's the life expectancy table, which is that table 1. Never, if you want to go look up the table, go ahead, but we do all the math for you here on the computer systems. And you have to start distributions in the year after the owner's death. So if it's 2022, you don't have to start distributions until next year, but you have to take money out by December 31st of 2023, subject to that table 1, subject to the schedule, and then each year you'll be taking out some amount from that IRA until it's exhausted. And again, I just project it could be a 15 to 20 year schedule. You can always take out more, but if you don't take out the required amount, there's taxes and penalties and it becomes a little bit costly. So you want to make sure you at least take out the minimum. But keep in mind, you can always take out more, and that's where a little bit of the advanced strategies, if you would say, come in. I'll talk about those in a little bit. But if you are not an eligible designated beneficiary, right? So if you're not the owner's minor child, you're not chronically ill, you're not disabled, and you're not within 10 years, then you're not an eligible designated beneficiary. You're just a designated beneficiary, right? So there's eligible designated beneficiaries, and then there's just designated beneficiaries. So if you're a designated beneficiary, there's something called a 10-year rule, and that's when you have to take monies out by the end of the 10th anniversary, the year that contains the 10th anniversary of your loved one, we'll say, is passing. So we're in 2022. If you inherit an IRA this year, you have to have all the money out by December 31st of 2032. Now, it says you have to have all the money out by the end of 2032. It doesn't say how much to take out each year. It's just that they want all the money out. The IRS is requiring you to take all the money out by the end of the 10th year. You can take a little bit this year, a little bit next year. You can wait till the end and take it all lump sum. But this is a little bit where strategies come involved. So if you are subject to the life expectancy tables, if you're subject to the life expectancy tables or the 10-year rule, keep in mind, life expectancy, there's a minimum you have to take out. 10-year rule, there's no minimum each year. Just get it all out by the end of the 10th year. But this is where your own personal plans now have to maybe just be reevaluated in light of these monies coming in. So some things I suggest people do are, if you have an inherited IRA and you're not a spouse and you're subject to either life expectancy or 10-year rules, think about your own personal tax situation, and if you can potentially manage these distributions such that you can take them out in the most in the least taxing way, meaning if there are years where you expect more income, I would just take out the minimum and the minimum. But if there's years when you're going to have less income, or if you're retiring soon, maybe try and delay. You know, try and take less distributions while you're working and earning, and then just take more monies when your income is less, and that'll just help with the tax impact of this. And further, if you're still working, and let's just say if you need these monies to live off of, well, then you're going to have, then that's, I can appreciate that. But if these monies are unexpected and they can be helpful and be saved, you can potentially take money out of the IRA subject to minimum distributions or more, and you can use this to help you fund your 401k at work. You can help it to fund an IRA. You can help it to fund a Roth IRA for yourself. You can't convert beneficiary IRAs to beneficiary Roth IRAs. You can't do that. But think that, say your distribution's $20,000 from a beneficiary IRA, and you kind of just don't need the money. You're working and you're contributing to your 401k plan at work. Well, potentially you're eligible for a Roth IRA. Maybe you're already doing one, maybe you haven't, but you can take these monies out and then you can recontribute them to other accounts and get the tax benefits related to whatever other account you go into, whether it's an IRA, a 401k, or a Roth. Now, it's not a rollover, it's not a conversion. You take the money out, you pay the taxes on the distribution. Now the money's yours to choose what to do with whatever you want. Maybe one of those accounts is another option for you getting monies into. And so those are some things with regards to these, where if there's a minimum, if you're subject to life expectancy, there's a 10-year period, if that's the rules, and it's just managing the distribution so that they're not, I wouldn't delay. Keep in mind that 10-year rule, if you delay until the end, if you have a $100,000 IRA, inherited IRA, and you delay distributions because you don't have to take any, but you have to take all the money by the end of the 10th year, well, if that IRA, $100,000, even with no growth, you're going to have a $100,000 distribution in 1 year. I know that's more taxing than taking out $10,000 a year. More than likely, it's going to put you into a higher tax bracket unless you're already in the highest tax bracket possible. So just want to think about some things. Let me go back to my chart, some other notes here. In doing this, when I was coming up with this, it's children of the deceased seem to be the most affected. And what I mean by this is if someone passed away prior to 2019 and they're an adult child, if an 80-year-old and 90-year-old passed away and their 40 and 50-year-old adult child inherited their IRA, that adult child was subject to the life expectancy tables. And so you would just take out a small percentage every year based upon the beneficiary's life expectancy. Now, if you're an adult child and your parent is obviously going to be more than 10 years older than you, if you have an 80 or 90-year-old parent who passes away and now in your 50s or 60s and you inherit their IRA, you're subject to getting that money out within 10 years, and it's no longer stretched over your lifetime. The most affected by this are children beneficiaries So we did this is where we had done a whole bunch of work planning for parents to pass IRAs to their children and get these lifetime stretch options prior to 2019. That's all been undone. If you inherit an IRA from your parent, you're going to have to distribute monies over a 10-year period. And again, just encourage you to look at it so that you don't delay, and then have this big taxable distribution in the 10th year. You just may want to look at it, take monies out judiciously over the 10-year period, or in some way that's going to be less taxing to you than waiting until the end. Something else to note is that if you inherit a Roth IRA, if the Roth owner dies, the minimum distribution rules that apply to traditional IRAs apply to Roth IRAs as though the Roth IRA owner died before his or her required beginning date, which essentially is just going back to those life expectancy and 10-year tables again. So the rules have changed for Spouse beneficiaries, I would suggest not a tremendous impact, but to non-spouse beneficiaries, you have been impacted, whether you're an eligible designated beneficiary or if you're within 10 years or not of your loved one's passing. Just things to be aware of. The rules are the rules. It's getting very difficult to come up with techniques to keep these taxes deferred, and that was the reason for that Secure Act. I mean, they kind of caught up with us. But some things to be aware of, and hopefully this was helpful. I'll link below this link to the bill itself from Congress and to the IRS publication 590, where I got all this information. Additionally, in the notes below, you'll see that I have some guides to financial planning, retirement tips, Social Security. I'll link those below so that there's some other tips and tricks still available to help you with. And thanks for watching. Hope you found this helpful.